This presentation will cover Chapter 15, our final chapter for the year, which is on criminal trials, appeals, and other post-conviction remedies. Okay, trial by jury is guaranteed by the Sixth Amendment to the Constitution, both a right to a speedy and public trial by an impartial jury. It extends to the states through the 14th Amendment, though it is not granted to juveniles or petty offenses, such as any offense for which you could only be sentenced up to 6 months in jail. It would be considered a petty offense. Now in Texas, we are a little bit different. You're guaranteed a jury trial in any case that you request it. It's not the norm to have a jury trial on a traffic ticket, but if that's what you demand, you do get it, and they do occur. Defendants who do not want to be tried by a jury may be tried by the judge. It's called a bench trial, and he will determine guilt and innocence, and he also will determine punishment. You can also have a case where you have the guilt and innocence determined by the jury, and the judge determines the punishment because we've got a bifurcated system of trials. First, you have a guilt and innocence phase. If you're convicted, then you have a punishment phase where new evidence put on to show mitigating reasons for punishment or other reasons to make punishment more severe. Jury selection involves several steps. First, you're summoned to be on the veneer, which is the panel that we select our jurors from. You can be summoned to this jury based on many factors. In Texas, it used to be just on voter registration, and they found a lot of people didn't register to vote solely because they didn't want to be picked on a jury. Now our panel comes from both the voter registration and driver's license pools, so that gives you a much larger pool to choose from. The next thing you have is the voir dire process. That's the process where you actually cull down the jurors. You can have jurors that are eliminated for cause, which means that there is some reason that they cannot be adequate as a juror. Either they're prejudiced against somebody, either side in the trial. They may be against sex offenders to the degree that they couldn't process all the evidence, thinking that anybody who has been charged with the crime must be guilty of the crime. Or they could be the opposite. They could be, I couldn't convict anybody. So either way, they could be thrown off for cause. Or they can be thrown off because of a preemptory strike. And each side has a number of preemptory strikes, and then they can eliminate people because they don't like the purple shirt they're wearing, or they don't like the way they answered the question, or they don't like the fact that they know a lot of police officers. Various reasons. They can strike them for any reason except a discriminatory reason. They can't strike them because they don't like their race. They can't strike them because they don't like their sex. But just about any other reason they can use to strike them. We'll talk about the types of evidence now. We've got testimonial, real or physical evidence, or scientific evidence. And testimonial evidence is oral testimony given under oath. It can be eyewitness testimony. It can be the testimony about the real evidence that you collected, or the scientific evidence that you performed some type of test on. It's the actual testimony part. Now, real or physical evidence is a tangible object or even trace objects. So it could be things like the knife used in the murder. It could be the baseball bat they used to break the window out, or it could be the fingerprints that you left at the crime scene. Those are physical evidence. Scientific evidence is the formal results of forensic investigation. The actual fingerprint is physical evidence. The comparison of that fingerprint to the known prints of the suspect is scientific evidence, and it's expert testimony, which falls under expert rules, where the person testifying can express their opinion. Now, you also can be taken on voir dire as an expert witness, where you have to prove that you are an expert on the particular field before you can give your opinion testimony. Demonstrative evidence is evidence that is visual or auditory, used to assist the fact finder or understanding of evidence, and it can be things like charts, maps, or videos. It could be the video from the crime scene. It could be a video explaining a procedure that's used to do a scientific investigation. Charts, we all often do fingerprint charts to show the points of comparison. That's demonstrative evidence, where I'll get up and show the fingerprints with the points of comparisons marked on the latent print and the known print, showing they're in the same relative location. It helps the jury understand how you made the comparison. Judicial notice is the process whereas the trier of fact accepts certain facts as true without necessity of formal proof. It's kind of a shortcut. It's called stipulation. You'll stipulate to the fact that your client's fingerprints are the same as the fingerprints on a pin packet to prove up the fact that he's been previously convicted of an offense. They can make you actually testify about it. And it was common when I do a lot of pin packets where you would go, the way it works is they'd get the package from the prison system that showed the person that went to prison for a particular offense, and the packet had a copy of the fingerprints of the person in there. And what you would do is roll the prints of the defendant in court, or in the judge's chambers or an office outside the courtroom, and then compare the prints to the fingerprints in the pin packet. Then you would get on the stand and testify that the prints were the same, and then they would enter that pin packet in that would prove up that his previous conviction. Now, more often than not, when I would go to testify on these cases, I would roll the prints, I would be there ready to testify, but when it came down to actual testifying, the defense would go ahead and stipulate, as long as there was an expert in the wings, because it just speeds up the trial. They know we're going to testify that it's the same person. But if you didn't show up to do it, then they would claim, oh, no, you don't have anybody there to prove it up. The presumptions at the beginning of a trial are two. One, we're going to presume that the person on trial is sane, that they're not crazy, that they can stand trial. If the defense wants to say their client is insane and should not be found guilty because of this insanity, then they're going to have to prove it up. They're going to have to let the defense know, or the prosecution know, that they're going to plead insanity, giving the prosecution an opportunity to prove up otherwise. They're also going to have to, the other presumption you have, is there's a presumption of innocence. Everybody is innocent until proven guilty. The defense is under no obligation whatsoever to present any evidence to show that they are innocent. The state must prove each and every element of the crime to prove that the person is guilty. And if you don't prove it, the defense can rest and actually ask for a directed verdict, and they don't have to put on any evidence. Now, the fact is that very seldom does a directed verdict come about. It does occasionally. Normally they're going to have to put on some type of defense, and they're going to try to discredit the prosecution's case. They may try to say someone else did it. They may just try to say, throw some confusion. All they need to do is raise a reasonable doubt that the defendant is not guilty. If they raise this reasonable doubt, then the jury must find the person not guilty. Evidence consists of the physical objects of testimony, and there are two different types. There's direct evidence, which is first-hand evidence that does not require presumptions or inferences in order to establish the proposition of the fact. Direct evidence would be testimony of a witness who saw John Doe shoot John Smith. That's direct evidence. They're testifying about what they exactly saw. Circumstantial evidence, on the other hand, is indirect evidence that requires an inference to be made. So it could be testimony that I saw John Doe enter the house where John Smith was murdered. That doesn't mean he murdered him, but it puts him at the scene. It could be that we found his fingerprints on the murder weapon. There are many other ways that his fingerprints could have gotten on the murder weapon besides being the one that committed the murder. But that's circumstantial evidence, and you build the circumstantial evidence up, and it will tend to show that the person is guilty. Again, the burden of persuasion is, or the burden of proof lies with the prosecution. They have to prove beyond a reasonable doubt that something occurred. There are certain things that we only have to prove by preponderance of the evidence or clear and convincing evidence, but on a criminal case, to prove guilt or innocence, you have to prove beyond a reasonable doubt. Now, there are many affirmative defenses that the defense has the burden of proof. So if you want to say that you're innocent because it was self-defense, the defense has to prove that they were, committed this crime out of self-defense. That it was, that the act that they did was excused because they were defending their own life, or that it was out of necessity because the only way they could survive after a hurricane and there was nothing to eat, so they broke into the building to get food to survive on. The government bears the burden of proof at all criminal trials, with the exception of the affirmative defenses, and that falls on the defense. Let's break down how a trial starts. Once the jury is selected and seated, then we start with opening statements, and both the defense and the prosecution get their say in opening statements, and they generally have a time limit within which they have to complete their statement. And what they're going to do is they're going to lay down their case. They're going to say, during this time, we're going to prove the elements of the crime. They'll lay down the elements of the crime and that the defendant did them. Then the prosecution is going to get up there and going to say, well, the state has to each one of the elements beyond reasonable doubt, or that there were other people that could have committed this crime. They're going to lay down something that will bring doubt to it. Once the opening statements have been completed, then the prosecution is going to start with their case. It's called their case in chief, and that's when they present their original evidence. They'll put on witnesses. They'll do what's called direct examination, where you question your own witnesses. Defense does direct examination when they present their witnesses, and the prosecution does direct examination when they present theirs. So in the original case in chief of the prosecution, the witnesses all go under direct examination from the prosecution. Then the defense has their turn to ask them questions after the prosecution's through, and that's called cross-examination. And when they're through with the cross-examination, the state can go in and clear some things up, and they call this redirect. And then you can have recross, and you can go back and forth until both sides get everything in that they think they can get in. Then the state will present all their witnesses. Then they will rest, and when they rest, the defense now has their turn to present their case. Or what they'll often do, they'll make a motion for acquittal based on, or directed verdict by the judge, because they say there's a lack of proof beyond a reasonable doubt. This is seldom ordered. I've seen it ordered a few times, but it's rare. Normally, they're going to then have to put on their side. The defense then puts on their side. However, they don't have to. They can just rest and let the jury decide, but normally they'll put on some type of defense where they will question their witnesses on direct examination, and now the defense or the prosecution gets to go with cross-examination on the defense's witnesses, and they'll do their whole side. When they're finished with their witnesses, they'll go back and forth just like we did during the prosecution's case in chief. And then when the defense is through with theirs, then the state can go have another chance to bring on more witnesses. So the prosecution will bring back witnesses to clarify things that the defense brought up. And again, we'll go with the direct and cross examination. And eventually both sides will go back and forth. When both sides rest, then we start with closing arguments. And the way closing arguments work in Texas is you have a certain amount of time allotted by the judge, and the prosecution goes first, and then the defense goes, and the prosecution gets to go one more time. So they get to stay part of their allotted time and get to split it in half, or split it however they want. So if they get 30 minutes, they may talk for 10 minutes, the defense will talk for 30 minutes, and the prosecution will finish their up. They'll be able to talk for 20 minutes. But it kind of depends on how they break it down. Next thing is a very important thing is jury instructions. This is where you give instructions to the jury where you tell them what the law is, how they have to vote. You talk about lesser included offenses if they're allowed to vote guilty or not guilty on those. You may explain what evidence they can look at. And they'll spend quite a bit of time, and it's usually a conference between the defense and the prosecution where they write these instructions. And they give them to the judge, who then determines whether to go with them or rewrite them or exactly where they're going to go. And they'll negotiate it back and forth. Eventually, the jury instructions will be given to the jury, and they will be given the opportunity to deliberate. They'll first elect a jury foreman who will determine, be the kind of run the show. And then they will often take an initial vote, and then they'll go back and forth, and eventually they'll either come to a decision, or they'll have what is called a hung jury. If the jury cannot make a unanimous decision, then it's a hung jury, and the case can be then reheard or not, depending on what the prosecution decides to do. Normally, they'll base their opinion on whether to retry the case on where the split was. If it's 11 for conviction and 1 for acquittal, there's a good chance they'll retry it. If it's the other way around, 11 for acquittal and 1 for conviction, there's a good chance they won't retry it. Now, once we do have a conviction, the judge or the jury, depending on how it was elected, will pass sentence. There are going to be various sentencing schemes, including an indeterminate sentence, which is a sentence where you can be sentenced to a particular period. It can be like 5 to 99 years, and minimum of 5 up to 99. Or it could be like Texas, where you can be sentenced to 60 years, but you can really be paroled out in 30 or even less, depending on the type of offense it was. That's called indeterminate because you can parole out. A determinate sentencing is a mandatory sentence. We have determinate sentencing in Texas. If you get a capital case, the mandatory sentence is either life or death, and there's no parole, so there's no indeterminate amount to it. You're either going to be in prison for the rest of your life, or you're going to be in prison for the rest of your life, but that will be shortened by an execution. We also use determinate sentencing on state jail felonies, where you pretty much know the exact day you're going to get out of jail when you're sentenced. Judges can make the sentencing right after the case ends, or they can order a pre-sentence investigation where they actually will have the probation office go out and look at the person's background. They'll talk to his family to see if he's got a lot of family support. They'll talk to the victim. They may get victim impact statements, which can be given directly in court. And that helps the judge to determine what kind of sentence he wants to give out. And in those cases, that will take a little bit of time. So there will be a time lapse between the end of the trial and when the sentence is handed down. If it's a sentence that's going to the jury, they're going to do it immediately. As soon as they get the verdict, they can start the testimony on the punishment phase right away, or they can recess and start it the next day. But it's going to be a lot quicker because you won't have the you won't have the pre-sentence investigation that the judge would order. Probably won't have the victim impact statements, but the defense may bring in the victim's family to let the jury know how much they suffered. Of course, the defense is going to bring in their family to say that my boy's a good boy and you got family support, so if you give him probation, we'll make sure he doesn't mess up. The possible correctional fines or punishments are things like fines, which we generally have in traffic offenses as the only alternative. But you can also be fined for murder in Texas. You can get a $10,000 fine for murdering somebody. We can have things like revocation of licenses. You can lose your driver's license if you're convicted of drunk driving and things. Probation, which occurs when they sentence you to time in jail or in prison, but they suspend that sentence for a certain period of time, and if you behave yourself and follow the rules, then you don't ever have to go to prison. Then we have what are called intermediate sanctions, which are things like boot camps, which are very intensive programs, halfway houses and work programs where you work during the day but you have to report back at night. And the next level up are incarcerations, could be jails or prisons. And then if you got the indeterminate sentence, you can be paroled out before your sentence is up. With good time and good behavior, you can get a sentence greatly reduced. A judgment is the written evidence of the final disposition of the case, and it's signed by a judge or the clerk of the court. A judgment of the conviction sets forth the plea, the verdict, or the findings, and the adjudication and the sentence. Similar to a pen packet, the judgment will be in a pen packet, but if it's a misdemeanor charge in Texas, we just have the judgment, and the judgment will actually have the thumbprints of the individual that was convicted on them, which they'll do right there in court, right after you're convicted. So I've done pen packets on judgments also, but again, those are in misdemeanor cases. Once you're convicted, it doesn't mean it's over. There are many post-trial motions. First place, the defense is going to make a motion for a directed verdict or a judgment of acquittal. Then that doesn't work. They'll make a motion for a new trial, or they can make a motion for revision or correction of a sentence. These are things that you make inside the original court. These aren't appellate courts. These are things that you make to the judge in the court that tried the case. Now, there are other remedies after you're out of that court. If that didn't work, and it very rarely does, defendant can either make an appeal to a higher court based on some type of error made by the lower court, which can either the appellate court can order the case be remanded back to the lower court for retrial, or in some cases they can order that the defendant be acquitted based on whatever evidence that they find on the appeal. Next thing, after your appeals are up, you can also always file a writ of habeas corpus, which challenges a fact or duration of prisoner confinement on some constitutional level. That's going to be that they violated some constitutional right, and you can have those many years later.
Well, everybody, that concludes this presentation, and that concludes all the presentations for this semester. Good luck on your finals.